Give effect to Local Government Act, Amendment Act number 3. Who would like to move that? Nobody? Going to fail for the want of... I'll move it. Seconded by Paul Lonsdale. Are there any questions to staff? Vicky?
What's just been changed? Like what sort of impact will we see here?
What aspect?
Just of all these changes, how will we sort of notice the changes most dramatically?
I think the most dramatic changes are probably in relation to development contributions matters, but a lot of that will be behind the scenes work, but these are the immediate things that need to be added into this is the main part of this report today, is about including things that have to be included in the development contributions policy within a month of the Act having passed. Then there's future changes to be made to that policy.
So this is just about being incredibly cautious about making sure that we include everything that's going to come out of DCs into our plan, because if we don't, we have to get them back, and making sure that we actually are very well have thought through all the development that's going to happen in 10 years.
Yes, and there's a new provisions for reconsideration process and an objections process that's been introduced by the government. So there's development contribution objection commissioners who are appointed by the government, who, if somebody lodges an objection, we have to appoint one of those to hear the objection. There's also changes that will be coming through, and you'll see those in the future in relation to the documents for the long-term plan and the way that's set up. I don't know if Ian's got anything else to say on that.
I guess the next visible bits will be the significance and engagement policy, which we will be starting to engage with you. I think we're bringing to a workshop of councillors on the 8th of September. We're going to start that process, and we have to have the policy in place by the 1st of December. And then the second visible effect will be the consultation document to be prepared as part of the long-term plan process. That's quite a different approach to consultation with regard to the LTP.
So just, sorry to be pedantic, but in terms of significance and engagement, what changes in the Act?
We're required to have one. A significance and engagement policy by the 1st of December. And if you look at attachment 4, is it?
But do we define our significance ourselves?
Yes, but we have to consult on it.
We've always had to have a significance policy, but now the government in its wisdom says that's to be a significance and engagement policy, which actually is quite interesting, because it maybe takes some of our consultation away from very hard prescriptive processes into something that's more engaging in terms of communicating with our community.
Okay.
So what we're approving today is the process and attachment 4, as far as that goes, and the process that we're going to begin next week in terms of talking to our communities about the long-term plan and the financial challenges that we face. Yes. It will kind of morph into this and fit very well. Have to record my utter disappointment at the passage of the legislation in terms of the changes to the development contributions policy. We made a very strong submission and attended in person and made a strong case. A number of other councils also addressed the select committee on those changes, and I know that they will also be very disappointed that the government decided to proceed with that. Oh, well, Peter would like to make a comment, and then I'll take other speakers. About the fact that development contributions can't be used for libraries and swimming pools. So you can build a community hall, as soon as you put books in it, suddenly you can't charge DCs for them, and it's just absolutely beyond comprehension that here in Christchurch we've got new communities that are having to be, new community facilities that are going to have to be built in order to, provide for growing communities over in the southwest in particular, and and yet the people that are ultimately going to end up paying are the people that have lost their facilities in the earthquake. And I just think that that's wrong. I think that really the development contributions were designed to enable community facilities, and a library is not a nice to have, and nor is a swimming pool. So anyway, that's my view, and I expressed it at the time very, very clearly, and I had Paul Lonsdale with me at the time. Peter.
And just draw the council's attention, I think one of the sleeper, just following on Councillor Buck's questions, one of the sleeper changes in this that's not immediate, certainly not this year, and I refer you to page 399, and you'll see 1, 2, 3, 4, the fifth bullet point down, a new requirement for council to review their service delivery. The council must review its governance, funding and delivery of infrastructure services and regulatory functions, i.e. everything we do. And I think one of the issues that's going to come up is the council will need to have a discussion debate. Do we continue to run in-house the service? Do we contract it out? Well, it's going to be, I would anticipate, contentious, to put it mildly.
So what was the philosophy sitting
I think the Parliament, because this is Parliament made this law, with the government having promoted it, wishes to put councils in a position where, to put it colloquially, the cage is rattled, and that councils have to go through and think about the services they provide, how they deliver them from that point of view. Do they contract out services in that way? Because, you know, clearly you'll be appreciate the history in terms of contract out New Zealand going back some 20, 30 years now. It's had a patchy record, but I think, and of course, you'll see there in the reference, I think, the way it's worded is not clear cut, because they talk about, well, when you have significant change to service levels, how is that judgment going to be made? But the backstop is, but by 2020, we're going to have to go through at least one of these exercises, and then constantly after that. And to me, when you read the legislation, while the DCs and the significance engagement policy are this year issues, I just draw the council's attention and watch this space in terms of the service level review issue.
I just have a feeling that it might be after I'm gone.
What was your thinking behind the change? Just if you were so minded.
I think, well, but potentially they at least wish council to have a public discussion around that, and then potentially to lead to changes which afford opportunities for contracting out, perhaps, from that perspective.
There's possibly also a time the need to look at collaboration with other councils. So part of that service delivery review process, and because there's also an obligation to look at collaborating with other councils, so there may be an opportunity for services to be provided to councils jointly. Or thanks.
Okay, so Yanni, then I think it was, who was second? Glenn, and then Paul.
So, I just found it really interesting in the financial implications that we don't really have any sense of what they will be. Have you done any high-level work? Obviously, if we can no longer charge DCs on a number of our projects that we were going to charge DCs, what's the cost to us?
With the community facilities ones, we didn't actually have any in our 2013 DCP originally, so...
Except for cemeteries.
Except for cemeteries. We should have an indication of cost. I don't have it on me at the moment, but that will be clear from what's in the policy. I
think it'd be really good. I know, and I don't understand why we didn't have them in our 3-year plan, but I know as part of this year's annual plan we did put some in. I think it'd be really good for us if we'd had the ones that we'd had in, being able to attract DCs. What is the cost that the government have basically imposed on us?
I think it was probably, we can probably find it, because I think it was in the previous, or the report that brought the submission to the council, was the figures on how much cost difference.
And any kind of figures around the new compliance costs associated with this, with these changes, about reviewing all our service delivery mechanisms, etc. Like, is there any work done around how much we're going to have to extra pay to get this work done?
No, because I guess there's still some thinking to do about how the service delivery reviews will be done, and if they can be done in conjunction with other work, then that may not, be a cost. And for the development contribution policy, the reconsideration process, most of those costs can be put back on the objector. The council's own costs in terms of presenting its case can't. There's a need to consult on the significance and engagement policy, but it's probably
to get something back that just says, here's the anticipated cost, here's the budgets that we need to approve to do this work. And I think when we do I think this report's really good, so I really appreciate it. And we should actually get into habit when government changes legislation or introduces legislation, have a report like this that comes in front of us. But I do think we need to also just have a few lines about the expected cost to council from this new government legislation, because we're often criticised by government that we're ineffective and that we're inefficient. Actually, one of the concerns has been that they're imposing quite a lot of costs on us, and this is a really good example of where we're having to pick up additional cost imposed by government, and yet they're putting pressure on us to keep our rates low and to borrow less.
Phil, sorry, it was Glenn was next, but look, I'm going to let Glenn, then Paul, then... Yeah, you go, Glenn, sorry.
Right, thank you. Just in 4.32 with the annual plan there, I guess it would be the significance policy that would be used to judge what might be significant or material, because if I read that correctly, it's saying we wouldn't need to, or councils don't have to consult. My view is they'd be unwise not to consult, but is that what it's saying? It's if there's no significant or material variance from the LT.
We're in uncharted waters there, in that we've got a new process. We don't automatically now have to follow a special consultative procedure. We determine the consultation in accordance with Section 82. And yes, we will have to make a call as to what's significant or material, and that may be a different assessment than what we have in our significance policy, but that's something that we will have to address.
It's true, isn't it, that we're often at greatest risk when we don't consult, and that's proven to be the case, or consult sufficiently.
Yes, and as I say, we are in uncharted waters, and at some point the High Court may well determine what is significant and material in terms of differences required for an annual plan.
Just reading through the report here, it just seems to me that we are now going to be open to a lot more objections to our development contributions, and we may find ourselves in permanent litigation with opponents, which we will actually end up having to pick those costs up as well, along with the loss of the ones we can't actually now claim on it. Would you comment on that?
Because there's a two-stage process, they can choose to bring a reconsideration first, and that's just dealt with by council officers, and there's an informal process that's done under sort of at the moment anyway. But if they then decide that they're going to object, or they go straight to an objection, then the objector does have to pay most of the costs of that. If they then take that to litigation following that, then that will be an additional matter. But there hasn't been any proceedings brought in terms of the current development contributions policy, so I don't know that there would be more litigation. I think, arguably with the objections process, that's a better chance for views to be aired. So there's perhaps, if there was going to be litigation, it'd be less, because there is that new process provided for.
So I just want to be quite clear that the staff costs, the legal costs are all covered. We can claim all that back off the objector if it's...
Our costs of presenting our side of the story at the objection, we have to pay for ourselves, but the council's costs in terms of staffing, providing resource to the commissioner to hear the objection and the providing the facilities or other things that they require, that's all has to be paid for by the objector. So
essentially, if we will be paying for our staff costs. If there are more objections, there will be quite an increase in cost.
Yes, in terms of staff having to be there to appear at objections.
Yep.
Yeah.
Thank you very much. So I'll put the motion. All those in favour say aye. Those opposed say no. That's carried. Thank you very much, and thanks for such a big effort with respect to this work. Much appreciated. Wasn't of our choosing. No notice of motion. Right. Resolution 2.